My name is Jessica Day, and I'm the Victim Witness Coordinator for our Victim Witness Assistance Program here in Mariposa County. This week, as we consider how to renew our support for victim rights within our judicial system, it is important to understand where we came from. In 1965, California established the first crime victim compensation program. Then, in 1976, the first victim impact statement was created and read to the courts from work from the Fresno County Probation Department. The first Crime Victim Bill of Rights passed in Wisconsin in 1980. Thereafter, in 1981, Ronald Reagan proclaimed the first ever Crime Victim Rights Week. In 1982, President Reagan appointed a special task force on victims of crime. Results showed over 68 recommendations to improve the treatment of crime victims, including an amendment to our Sixth Amendment, which guaranteed victim rights to be present and heard at critical stages throughout the criminal justice process. In 1984, the Victims of Crime Act passed and established the Crime Victim Fund, which comes from federal criminal fines and penalties to support state compensation programs and local service programs like ours. In 2008, here in California, we passed Marsy's Rights that expanded on the already present federal guidelines. California voters passed the Victim Bill of Rights Act of 2008, Marsy's Rights, on November 4th, 2008. Marsy's Law changes the Constitution of California, Section 28, Article 1, to provide a general victim bill of rights during criminal, juvenile, and parole matters. These rights are as follows. Number 1, to be treated with fairness and respect for his or her privacy and dignity, and to be free from intimidation, harassment, and abuse throughout the criminal or juvenile justice process. Number 2, to be reasonably protected from the defendant and persons acting on behalf of the defendant. Number 3, to have the safety of the victim and the victim's family considered in fixing the amount of bail and release conditions for the defendant. Number 4, to prevent the disclosure of confidential information or records to the defendant's attorney, or any other person acting on behalf of the defendant, which could be used to locate or harass the victim or the victim's family, or which disclose confidential communications made in the course of medical or counseling treatments, or are otherwise privileged or confidential by law. Number 5, to refuse an interview, deposition, or discovery request by the defendant, the defendant's attorney, or any other person acting on behalf of the defendant, and to set reasonable conditions on the conduct of any such interview to which the victim consents. Number 6, to reasonable notice of and to reasonably confer with the prosecuting agency, upon request, regarding the arrest of the defendant if known by the prosecutor, the charges filed, the determination whether to extradite the defendant, and upon request to be notified and informed before any pretrial disposition of the case. Number 7, to reasonably notice of all public proceedings, including delinquency proceedings upon request, at which the defendant and the prosecutor are entitled to be present, and of all parole or other post-conviction release proceedings, and to be present at all such proceedings. Number 8, to be heard upon request at any proceeding, including any delinquency proceeding involving a post-arrest release decision, plea, sentencing, post-conviction release decision, or any proceeding in which a right of the victim is at issue. Number 9, to a speedy trial and a prompt and final conclusion of the case and any related post-judgment proceedings. Number 10, to provide information to a probation department official conducting a pre-sentencing investigation concerning the impact of the offense on the victim and the victim's family, and any sentencing recommendations before the sentencing of the defendant. Number 11, to receive, upon request, the pre-sentence report when available to the defendant, except for those portions made confidential by law. Number 12, to be informed, upon request, of the conviction, sentence, place and time of incarceration, or other disposition of the defendant, the scheduled release date, and the release of or the escape by the defendant from custody. Number 13, To restitution. It is the unequivocal intention of the people of the state of California that all persons who suffer losses as a result of criminal activity shall have the right to seek and secure restitution from the persons convicted of the crimes causing the losses they suffer. Restitution shall be ordered from the convicted wrongdoer in every case, regardless of the sentence or disposition imposed in which a crime victim suffers a loss. All monetary payments, monies, and properties collected from any person who has been ordered to make restitution shall be first applied to pay the amount ordered as restitution to the victim. Number 14, to the prompt return of property when no longer needed as evidence. Number 15, to be informed of all parole procedures, to participate in the parole process, to provide information to the parole authority to be considered before the parole of the offender, and to be notified upon request of the parole or other release of the offender. Number 16, to have the safety of the victim's family, and the general public considered before any parole or other post-judgment release decision. Advocates who have come before me and entire movements have made federal and local changes possible for victims across the nation and the world. The importance of a victim's voice cannot be understated. Voices matter. The importance of a victim's voice, and these voices are the same ones that won a bipartisan vote as President Reagan passed the 1984 Victims of Crime Act, a crucial tool to be able to continuously provide services to victims in our communities. These are the same voices that fought for respect and consideration through the criminal justice process. No longer a witness, but an active participant. The strength of survivors overwhelms and empowers our office to continue to fight for victims to have a voice and to identify gaps in which they can be served and supported properly. As we look back on these rights that are enumerated in our California Constitution, I stop to consider that each number represents thousands of stories and narratives about the natural injustices that victims have endured for so long. So as we remember these advocates that came before us, let us also remember the victims that are no longer with us. Let us use their tragedies for change so that victims are supported and listened throughout the criminal justice process. May we continue to seek justice, ensure victim rights, and inspire hope.